Honorable J. Keith Cohen, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. And God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Well, good morning, everyone. Happy holidays. We're here for an oral argument session of the 5th District Court of Appeal, as you've heard, and I've been introduced. To my right, we've got Judge Rand Wallace from Orange County. To my left, we've got Judge Sasso, Meredith Sasso, also from Orange County. So you have an Orange County panel this morning. We've got 3 cases on the docket. 2 of them are criminal, 1 civil case. When I do this, I have a default of 5 minutes for rebuttal. If you'd like something other than 5 minutes, please let me know. I'll be more than glad to accommodate your request. If you have any electronic devices, just if you could put them on silent, that way they don't interrupt the flow of the argument. I see that we have a bow tie. Do we allow bow ties in the... Well, today we'll allow a bow tie this one day. So. All right. The first case we have on the docket is Jason Downs versus State of Florida.
Good morning, Your Honor. May I please the court?
May. Good morning, Mr. Downs.
I do have a couple of housekeeping matters before we begin, if that's okay.
Well, I don't know. Why don't you start and we'll go from there.
Thank you, Your Honor. First and foremost, it's a pleasure to be here before this court. This has been a 21-year journey to get here. I am representing myself, but I wanted to inform the court that during the pendency of this case, the state of Florida did see fit to grant me my law license. So if the court would like my bar number to attach to the record,
It's unnecessary.
okay, thank you, Your Honor. Then I'll begin. This is again my case. This began in 1998, and we're here under appeal from Judge Reinman's order denying post-conviction relief on 2 grounds. The first ground is that trial counsel, Mr. Daniel Senior, was deficient and prejudicial in his representation because he used a blanket policy or a blanket strategy in all of his cases, including mine, rather than a case-specific trial strategy.
I think you understand this, Mr. Downs, that what we're going to be addressing today are grounds 1 and 2.
Correct.
Of the motion for post-conviction relief, and we're not in a position to go back over 3 and 4. And so
Correct.
Let's assume for the sake of discussion that we agree with you that Mr. Senior's strategy of always wanting the opening and closing back when that was an appropriate, when the law provided for that,
Yes, sir.
that was in some manner deficient. How do you establish prejudice based upon the record of what was presented at the post-conviction hearing?
That's a wonderful question, Your Honor. And in fact, this court has already held that blanket policy was per se deficient. And the way that the...
I wouldn't go that far. We've held that it was deficient when that was the only strategy, but there were other strategies in your case. I mean, he did have a theory of the defense.
I disagree, Your Honor. Respectfully, I disagree. Now, the trial court in its order denying said that there was a trial strategy, but that trial strategy hasn't been proven. And Mr. Senior, basically that trial strategy was that this was a neglected child who wanted attention from his mother. There's nothing on the record that shows that, Your Honor. And
You've got to, you have to make some argument.
Yes, Your Honor, and the argument that I'd like to make, Your Honor, is through the two
I'm
evidence...
saying that he does. As defense attorney, you have to have some theory for why the child is going to be, as you're claiming, making up, these allegations.
Yes, absolutely. But Mr. Senior did not proceed to trial with any kind of theory, including the neglected child theory that the trial court in its previous order denying, which was reversed by this court, has fabricated. It didn't happen. It was Mr. Senior didn't explore that theory in any way, shape, or form. It was just a theory that he brought up during the evidentiary hearing all of these years later. But at trial, he never explored the neglected child, seeking attention from his mother theory. He did nothing through his cross-examination of the state's witnesses to draw attention to that, and he didn't make that a feature of the case. So he did go in with zero trial strategy. And in fact, Your Honor, to answer your question, there were 6 facts that came out during the 2 evidentiary hearings.
I'm going to keep getting you back to your motion for post-conviction relief.
Yes, Your Honor.
And as I read it, when we look at those first 2 grounds, you've got not presented a defense theory when 2 available defense theories existed. That's 1.
Correct.
And not calling exculpatory witnesses. That's 2.
Yes.
So with that in mind, go ahead.
Thank you, Your Honor. During the 2 evidentiary hearings, based on those 2 grounds alone, there were 6 facts that came out.
Only addressing the last evidentiary hearing, not the one before it.
Okay, Your Honor, so I will skip the first 2 facts that came from that one, and we'll go directly into facts 3 through 6 as I've enumerated them here. First and foremost, at the second evidentiary hearing, the sister, or the older sister of the accuser, we'll call her Angela, testified that she would have rebutted the accuser's testimony.
I didn't read it that way, and that's the difficulty I had, because I'm troubled by some of the facts in your case. I'm troubled by the lack of any DNA on the couch.
Right.
That seems, under the victim's statement of what occurred, should have existed and didn't exist. And so I'm not unsympathetic to that, but I don't think that's what she testified to.
Your Honor, my argument is that Angela testified that she was at the house that night, which rebuts the accuser's testimony that nobody else was in the house. His testimony at trial was that Angela was off at a school dance. That was also the testimony of the mother at the child victim hearsay hearing that the trial court has relied on in its defense of Mr. Senior. But Angela did testify that she was there that night. So that in and of itself, but beyond any other fact, is a rebuttal of some way, shape, or form to the state's only direct witness.
Mr. Downs?
Yes, Your Honor.
Is the woman that you're talking about now, as far as being an exculpatory witness, would that witness have had proven that you were at no time alone with the victim?
It's a tricky question, Your Honor. I'll answer it the best I can.
It's not a tricky question.
My argument isn't that I was never alone. The argument is that on this day, during this alleged incident, I was not so alone to have been able to have the opportunity to have commit the alleged crime. And Your Honor, I do believe that that's what Angela's testimony would have been, because she testified at the evidentiary hearing that she heard the alleged encounter between her younger brother and I, that she didn't hear anything out of the ordinary, she didn't hear anything that alarmed her, and she didn't hear anything that made her want to get out of bed to investigate. It was nothing out of the ordinary. And this is a single alleged incident that allegedly occurred at that time that she was discussing. And she testified that had defense counsel contacted her back then, had she been called to trial, that's what she would have testified to. And Your Honor, the case law that we have and the case law that you're well aware of gives us a may, could, or could have standard here. All of it says if the evidence that was left out could have or may have changed the outcome of the trial. And that's under the Strickland v. Washington and all of the other case law that followed that. My argument today before this court is that Angela testifying, I was in the house, after her brother just testified she was not in the house. And then Angela testifying that I heard the alleged incident and nothing alarmed me about it because I didn't hear anything out of the ordinary. Those two things may, could, or probably would have created reasonable doubt in the mind of a juror. And that's the prejudice. And I'm sorry it took so long to get back to that, Justice.
She stated, though, that she didn't remember whether she was at a school dance when at the time that this occurred.
I respectfully disagree, Your Honor. She was clear on the record that she was there, that she was not at a school
dance. The record
dance.
site is on page 335.
And I understand, but then she also clarifies under cross that she remembers being at the house Friday, Saturday, and Sunday, and she remembers being there during the alleged incident. And again, this is a singular alleged incident. It wasn't alleged that this happened on numerous occasions or that it happened on numerous days. It was alleged that it happened on this particular evening, and Angela was testifying that she was there and heard the interaction that evening.
She heard an interaction.
Absolutely, Your Honor.
Yeah. but she goes to sleep and there's no telling what occurred after she's asleep.
Absolutely, but then there's Holly. So Holly is the other exculpatory witness, who was my girlfriend at the time. She was the former babysitter of the two children. And Holly's testimony was that she doesn't remember whether or not she was there. My testimony was that she was there. The state has not been able to rebut that because neither Angela nor Holly have testified that Holly was not there. My allegation was that Holly we were in a dating relationship. She was spending those weekends with me. We were spending those weekends together at that house, and that she was there. So we have this other
Didn't she also
exculpatory
have
witness.
testimony about the proximity to her exams and the end of the semester, and then that would have required her to stay at school and not be there during that weekend?
That's correct, Your Honor. She testified that may have been the exam week. She was guesstimating, but that she said that she was still dating me and that she was coming home, and she still couldn't say, even if there were exams that weekend, it would have been, the exams may have been over at that point, or it may have been the weekend before exams. She wasn't sure, but that there was still a possibility that she would have been home that weekend. And again, my testimony is that she was home, and there is no testimony that says that she was not. There's none that refutes it. There is some that she may or may not have been.
Well, at best, it was unclear. Is that correct?
That's correct. Absolutely correct.
Your word versus her word.
Absolutely correct. I would say a little bit less than my word versus hers because she's not saying no. She's saying she doesn't remember. But had she been questioned by my counsel back then, her testimony was she certainly would have remembered. And I'm not raising the issue of latches here. That's not where I'm going. But had Mr. Senior done his job, his reasonable duty as an attorney back then,
You see the speculative nature of it, that she would have remembered, but we don't know what she would have remembered.
absolutely, Your Honor. But we also don't know what she would have forgot. And speculation in any defense theory is reasonable. We speculate.
Speculation isn't the prejudice standard, though, right? A reasonable probability.
I absolutely agree with Your Honor. But at trial, had there been a little bit of speculation, that would have been okay, and it would have been reasonable to put these things forth as defense theories, including the other man theory that we've discussed in my appeal. And this is something that we'd never heard until this second evidentiary hearing, and now we have Angela getting on the stand and saying, well, right before Mr. Downs started babysitting, there was this other guy that used to spend the night. And after 21 years, this is the first time we're hearing this information. And had Mr. Steiner interviewed, deposed, or called Angela at trial back then, this was another viable defense theory that could have been out.
Well, that's more, the Saudi, defense in this case is more speculative than, whether who was present and when they were present.
I totally agree with you, Your Honor. And what I'd like to point out to the court, though, is along with the facts that we've discussed, the standard here. The standard is a lower standard than what we have at trial for a conviction. The standard here, again, is may, could, or should have. This court, in its previous order, had already held that I'd shown a prima facie case of both prejudice and deficiency on Mr. Steiner's part, and the purpose of the evidentiary hearing was for the state to rebut.
I was on that panel, and what we held was that you were entitled to an evidentiary hearing on it.
Correct, Your Honor, for the purpose of the state rebutting the prima facie claims that I've already made.
Well, you have the burden of establishing prejudice.
I absolutely do, Your
not the
Honor.
state.
Absolutely. I absolutely do. I agree. And the prejudice, I believe, is apparent. The prejudice is that had Mr. Steiner called these exculpatory witnesses, it may have created reasonable doubt. And that's the standard. And if it may have created reasonable doubt, then this court should reverse the trial court's holding and reverse this conviction. This is I apologize, there's, in the Williams case, and we discussed the Williams case throughout all of the briefs, I believe. It's Williams v. State, and that court held our concern is not protection of criminal defense lawyers from post-trial attack. It is to enforce the guarantee that every defendant receives a fair trial. And that's all I'm asking of this court today, is to ensure that I receive a fair trial, because all of those years ago, almost 2 decades ago, I did not receive a fair trial, and that's the prejudice. Just like in Cole and in Han v. McDonough, where this court and the Middle District of Florida admonished Mr. Steiner for that exact behavior, the exact same trial strategy that he was using in my case, not calling witnesses as part of his blanket strategy, not investigating claims of innocence as part of his blanket strategy, and especially where there's no physical evidence in the case, This court and the Middle District admonished him. The Middle District called it startling behavior. And they cited this court, the Cole Court, by saying the 5th DCA has told him that he can't do that anymore, that it's per se deficient when he does. And yet a year after the Cole decision, a year after the Cole decision is when I was arrested. 4 years after the Cole decision is when I went to trial, and Mr. Siener was still doing this. He was still going in without any cognitive defense theory. And when you look at the case law that's laid out in the briefs, and I'm with the court's permission, I'm going to start wrapping up because I am running out of my original time, and I do want to save that 5 minutes for rebuttal. When you look at the case law, the facts are starkly similar. We have Siener going in without an attack plan, without investigating, without deposing any witnesses prior to trial. And he does it all to preserve this.
You hired him, you knew was the strategy.
I absolutely did, Your Honor, and based on the testimony, and I apologize, I have to bring up the first evidentiary hearing, but the testimony that was adduced there was that my father and I argued with him the whole time that we didn't like this strategy, but this was a non-refundable retainer. We were frankly stuck with him, and this court held in its prior reversal in Downs v. State that my hiring was unavailing.
Right.
Thank you, Your Honor. With the court's permission, I'll reserve the rest of my time for rebuttal.
Absolutely.
Thank you very much.
May it please the court, my name is Kaylee Tapman and I represent the state of Florida. The trial court properly denied both grounds
You know,
one
one
and...
of the things, just as an initial matter, one of the things that's exceptionally disturbing to me about this case, and I think it bothered the trial judge based upon the sentence that was imposed, was the lack of DNA evidence. I mean, you know, the testimony in this case was of a nature that there would have had to have been DNA evidence on that couch, and there wasn't. I mean, how do you get past that?
Your Honor, I would submit that the child victim testified as to what happened, and the jury clearly believed him based on the fact that the appellant was...
So you ignore it. Is that what you're telling me?
I think in this case, we have to look at the evidence that was presented, and that's what we have. That's what the state's case was. But the child victim testified as to what happened, and that's what the evidence at trial was.
Physical evidence you would concede was inconsistent with that testimony.
Maybe I don't know. The jury trial wasn't in the record on appeal. I've seen portions of it based on what the trial court has attached to its order. I think anything I would say would be speculatory as to...
All right, so would you concede that based upon our prior decisions that Siener's representation was deficient without talking about the prejudice prong?
I would say as to ground two, he should have talked to those witnesses. As to ground one, though, I would disagree. Whereas he did have a cognitive theory of defense, he did effectively cross-examine the witnesses. He didn't need to depose them because all the substantive witnesses as to what had actually happened, he cross-examined and heard their story at a prior child hearsay case. The only other witnesses that testified at the hearing that did not previously testify at the child hearsay were the actual victim and then two officers that just testified as to the lack of DNA evidence. And so in that case, there was really he didn't need to depose the other witnesses. He knew what they were going to say. He had a cognitive theory of the case going in. And he was able to secure a judgment of acquittal on the first count and successfully argued for a downward departure and a youthful offender. He was prepared for this trial. As to point two, however, I would agree that he should have talked to those witnesses. However, as Your Honor pointed out, the appellant was not prejudiced by their omission at trial. I think the way they testified at the evidentiary hearing showed that their omission was not prejudicial to the appellant. Holly, Ms. Benfield testified that she could not remember And as you pointed out, though, her exam week was over that week, and she generally didn't come home at that point.
Do we know that that was the week, that her exam was that week, or did she just think that it was, that it might have been that week?
She was guessing. She just didn't remember. She testified that her exam week is typically the first.
Isn't that problematical? I mean, had she been talked to at the time of the incident, she would have known.
She would have. However,
But Senior didn't do that.
Correct.
He didn't talk to her.
Correct.
He didn't call her as a witness.
correct. However, Angela, the victim's sister, did testify at the evidentiary hearing that Holly was not there that weekend. At one point, she conceded that it was possible that Holly had arrived after she had fallen asleep and left before she woke up, but she also testified that there was no indication whatsoever that that's something that actually happened that weekend. She testified that Holly was not there that weekend.
So the difference between Downs in this case, in your view, is what?
Between,
The prior
Cole?
decision on Senior's ineffective representation.
I think in some ways it's very analogous in the fact that Mr. Senior, or that the appellant was not prejudiced by Mr. Senior's actions. However, such as in Cole, he went in not knowing what any witness was going to
I'm sorry,
say.
I meant Cole.
Yes. He went in without knowing what any witness was going to say. That's not the case here. He went in without any cognitive theory of defense. That's not the case here. But as in Cole, the appellant was not prejudiced by his actions. And as the witness's testimony from the evidentiary hearing showed, that there would not be a reasonable probability that had those witnesses testified at the hearing that the outcome would have been different. In fact, the victim's sister placed them alone in a room together and then went to sleep. And testified that Ms. Binfield was not there that weekend. So I'm not sure that their testimony would have helped him at all at his trial. If there are no further questions, rely on the brief, ask that you affirm. Thank you very much.
Thank you.
May it please the court? First, I would like to bring up the issue in ground one. The state's position is that, basically that Mr. Senior did a stellar job throughout the rest of the trial.
I don't think that they're saying that. I think that they're just saying that the proof of prejudice is lacking.
Fair enough, Your Honor. The point that I would like to get at there is that even if we talk about Mr. Senior being okay in his representation in some areas, such as sentencing, an acquittal on count one, and areas like that, it's irrelevant.
What about just basic cross-examination? I mean, it's not like he sat there with his sat on his hands the whole trial.
Mr. Senior did a fantastic job on cross-examination. He's probably one of the best witness examiners in the state of Florida. He's phenomenal. But he was not phenomenal in other areas. In the areas where he was not phenomenal, he was deficient, and those are the areas that we need to focus on. The areas that he was stellar in are irrelevant to these proceedings.
Specifically, the areas where you say he was deficient was failure to expand upon, discover, and present testimony, which in its entirety would not have resulted in you being able to argue to the jury that you were not alone with the victim. Is that correct?
That is correct, Your Honor. And also, just as an example of the blanket strategy.
And the testimony would have been that there were opportunities for you to be in private without anyone else in the room with you and the victim at around the time where the crime was alleged to have occurred. Is that correct?
Your Honor, if I would have taken the stand, I would have testified to that. I was a caretaker for children. It would be preposterous to assert that I was never alone with the accuser. So that's not my argument. My argument is that on this occasion, I did not have the opportunity to become so alone with the accuser, to become fully nude, perform fellatio on myself, ejaculate orange semen, because those were the allegations, in the presence of a minor, and then scrub the entire home of any physical evidence before FDLE Crime Lab got their hands on the evidence. That's the argument, is that I couldn't have been so alone to have done all of that. There was zero opportunity to do all of that. That's the argument, and that should have been the trial strategy. But Mr. Senior's blanket policy of just going in to punch holes in the state's case and object to everything is evident in the fact that the trial court in their order denying talked about Mr. Senior's attention and his vigorous fight against the admission of the child hearsay CPT video. However, if Mr. Senior had actually investigated and actually developed a trial strategy, he would have realized that based on his own testimony, that video had
That's not part of your grounds 1 and 2 of your motion.
It's not in the motion, but Your Honor, it is in the brief. And what's discussed,
We look at the motion. You know, I look at your motion for post-conviction relief and the rulings that are made on that motion and the order that denied it. That's what we're here about, and we're not here.
I agree, Your Honor.
The fact that it's in a brief doesn't mean that it's an area
It is, I apologize.
that we review for error by the trial court.
It is in the order denying, though, Your Honor. In the order denying, the judge relies on Mr. Senior's vigorous objections to the admission of that video. However, that video, the court's reliance on it is erroneous because that video, the accuser recanted the story, and the accuser talked about there were inconsistencies in testimony, and that's where the orange semen and the self-fellatio allegation came out. This is a video that should have been shown to a jury. Any reasonable attorney would have shown the victim recanting the allegation in a child protective team video. They wouldn't have fought so vigorously to keep it out.
And were those topics addressed during cross-examination of the victim by Mr. Senior?
They were not, because the child video was out, so Mr. Senior didn't have any of that to go on at the trial level. So those were not discussed.
He didn't talk about I think the victim said white or white-orange, but it
Correct.
didn't just say orange. Did Mr. Senior talk about that on cross-examination of the victim?
I don't remember exactly how deep Mr. Senior went into cross-examination. My recollection is that he did not go that deep into that line of questioning. I see that my time is about to run out before I conclude. Are there any questions? Thank you very much. Again, I would ask the court to remember the facts that we discussed today. You've seen the case law, you've seen the briefs, you have seen that there was a lack of DNA and physical evidence in this case. But I want the court to remember that although the trial court apparently saw that, and that's why I received a somewhat light sentence with no prison, no GPS, and all that stuff, I have been branded a registered sex offender for the better part of the last 2 decades for a crime that I didn't commit. And so my sentence certainly wasn't light, and I would ask this court to bear that in mind when considering this case, and I would ask for a reversal on the trial court's order denying.
Thank you.
Thank you.